Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's video presentation is the concept of arbitration. So Section 2 of Arbitration and Conciliation Act defines defines arbitration means any arbitration whether or not administered by permanent arbitral institution. So arbitration agreement means an agreement referred in Section 7 of the Arbitration Act. And the basic definitions also include the arbitral award, which includes an interim award, and the arbitral tribunal, which means a sole arbitrator or a panel of arbitrators. And lastly, the basic definition is court, which means the principal civil court of the original jurisdiction in a district, and it also includes the high court in the exercise of its original civil jurisdiction, but not any civil court of a grade inferior to such principal civil court. Further, when an act defines a term, when an act defines a term, it is that definition that has to be taken whenever the term occurs in the act. But where the context in which the term is used makes the definition inappropriate, the ordinary meaning should be given to the term. Section 2, Clause 1, Sub-Clause A of the Arbitration and Conciliation Act talks about arbitration means any arbitration whether or not administered by permanent arbitral institution. Further, moving ahead, O.P. Malhotra on law and practice of arbitration and conciliation provides that there are four core ingredients or requirements of arbitration, which are the first one is an arbitration agreement, a dispute. Second one is reference to a neutral independent party for its determination, and the last one is award must be binding on both the parties. The UNCITRAL model or the Unicitral model law, which talks under which the Article 2 Clause A talks about arbitration as any arbitration whether or not administered by a permanent arbitral institution. Further, Indian Act through Section 2 Clause 1 Subclause A reproduces the language of the module law. Further, moving ahead, Section 7 of the Arbitration and Conciliation Act talks about the arbitration agreement, which is quite an important concept under this. So, the arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. Secondly, an arbitration agreement may be in the form of an arbitration clause in a contract or in a form of a separate agreement. An arbitration agreement shall be in writing, and further, an arbitration agreement is in writing if it is contained in a document signed by both the parties involved, and an exchange of letters, telegrams, or other means of telecommunication. Further, the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause a part of the contract. In the case of K.K. Modi versus K.N. Modi, which was about the arbitration agreement, in the case, it was held that the arbitration agreement must contemplate that the decision of the tribunal will be binding on all the parties to the agreement. Secondly, that the jurisdiction of the tribunal to decide the rights of the parties must be derived either from the consent of the parties or from an order of the court or from a statute, the terms of which make it crystal clear that the process is to be an arbitration. The agreement must contemplate that the substantive rights of parties will be determined by the agreed tribunal, and further that the tribunal will determine the rights of the parties in an impartial and judicial manner, with the tribunal owing an equal obligation of fairness towards both the sides. And moreover, that the arbitration agreement of the parties to refer their disputes to the decision of the tribunal must be intended to be enforceable in law. And lastly, the agreement must contemplate that the tribunal will make a decision upon a dispute which is already formulated at the time when a reference is made to the tribunal. In another case, which was the Bihar State Mineral Development Corporation versus Encon Builders, the two-judge bench enlisted following essential elements of an arbitration agreement, and the first one being there must be present or a future difference in connection with some contemplated affair. Second, there must be the intention of parties to settle such difference by private tribunal only. The party must agree in writing to be bound by the decision of the tribunal, and the parties must be ad idem. The arbitral award must include an interim award also. So this was the concept of arbitration under the Arbitration and Conciliation Act. I'll continue the same topic in the second video. Thank you.